Hello, everyone. Welcome back to Open Line. Glad you are with us. We are talking with Tim Takacs, elder law attorney Tim Takacs. He's joining us via Zoom from his home. Happy that he is with us. And we just had a great call. We had a great call from Michael, also a good call from Carnelita. Michael asking about durable power of attorneys, or durable powers of attorney. And, let's say you have two children, they are equally capable. How do you determine who goes on there? And you had a great answer, I feel like. But then you wanted to get into springing power, and I've not heard that.
Springing power.
What are we talking about there?
Oh, springing is like a spring in a mattress. It's something that springs into being, and it sounds like maybe that's what I ought to have. I'd never heard of that before because. I'm going to name. I've been asked I should do a durable power of attorney, but I really only want to use it, or only want it to be used in case I become disabled or incapacitated. So I want the lawyer to write into my document that says that two physicians have to say that I'm disabled or incapacitated before my son or daughter can take over my affairs, and that sounds like a good idea, but it's not, because, and in fact, I'm thinking that I can't remember the last time that I've done a springing power of attorney. Maybe in the 90s,
right?
Because basically, what you have is that you're naming you've got a document that you feel like it's a basic document that you need to execute or have in place, which essentially says that someone needs to be able to step in and pay my bills, to make decisions for me if I become disabled or incapacitated. But I don't want anybody to have that authority right now. They have to wait, until I become disabled or incapacitated. So I'm going to write that into the document.
Right.
Well, and that sounds like a good idea. The problem is that if someone does not have authority to act for you, then how are you going to go to a doctor and ask them to write a letter for you? It says that your father, can't make decisions for himself.
That's a good point.
Do you really want to put that burden or place that? How important of a stumbling block or impediment is that? Do you really want that to be? If you don't trust your children, to act for you right now, you certainly aren't going to trust them to act for you when you're disabled or incapacitated.
Yeah, that springing power thing that you're talking about would indicate they don't trust their kids. And it could become a bureaucratic red tape kind of thing to try and get two doctors to sign off. It's obviously a difficult time, and I think you're right. It sounds maybe good, but it's not practically a good idea.
Yeah, and here's another thing is that, and I've always said this about that determination. Okay, a doctor writes a letter that says blah 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 blah. You can't take care of your legal or financial affairs. Well, that's not a medical conclusion. That's a legal conclusion. I mean, the doctor can make, the doctor is, you're asking the doctor or the physician to maybe stray outside of his or her comfort zone. We really don't want because in many cases, a physician might say, no, I really am not able to write that letter. And then you start running into those barriers, and you can't force the treating physician or your primary care physician to write that letter.
Right.
Essentially, you're leaving it up to that person, to decide whether or not you wind up in court. And the doctor might say, no, I'm not going to write that because I can't say that for sure. And here's daddy over there doing all sorts of crazy stuff. And so you wind up, having nobody to, you have nobody that's has any authority at all, and that's how you wind up in court.
Fascinating.
And our clients want to maintain control, and that's one of the ways they maintain control. Like when we were talking to Mike about his children, is talk to both of your children about what your expectations are. and have the what if conversations. So it's not just, okay, you've got this person first and this person second. You expect them to work together. The authority that they have to act for you is effective immediately. You don't expect them to use or abuse that authority, because if they did, you can always revoke that authority and name somebody else.
Okay, that's good.
So there are a lot of options there.
Let's go to William. Hello, William.
Yes.
Are you there? Go right ahead. What's on your mind?
Hello.
Hello, what's on your mind, William?
Yes. I have got a question. I was brought up here from Fort Lauderdale, Florida, to go to school to become a personal assistant for the disabled, and I've been here a year. And due to the new government clock in and clock out procedures via an app on your phone, for whatever reason, I was not meeting the clock in and clock out time appropriately. I'm a live-in for the disabled. I take care of a 73-year-old disabled man who's mentally challenged. And I was let go last week, and now it seems that I've been brought up here for a career, taking care of this elderly gentleman as a live-in, and all of a sudden, because my clock in and clock out procedures are incorrect, I'm being let go. I have to find a new apartment, a new job, little to no savings. I was just wondering if maybe there was any kind of input on this. It just doesn't seem very legal.
Now, were you working with a home health care company? Is that what it was?
Yes, it is.
So a home health care company, and you were fired because of the clock in, clock out. All right. Well, let's talk about some of these issues. I know you don't do employment law.
Right.
I know you know a lot about these home health care companies. What do you think about that call there?
Well, I think one question I would have is, are there terms of employment that he has?
Let's see.
In other words, is there a contract? Are there letters? Are there emails? Are there other things that that set out the terms of your employment? I also think that I'm sort of trying to pull this out of memory about since we are in an unusual period, in our nation's history, about what options or what limitations that employers have, on reducing hours or even or terminating employment. I'm going to suggest, William, that and you may have heard me, or we may have done it during a break, but you're certainly welcome to call the office or call my office. We'll have the contact information, because it's something it's something that I can talk to my team, and see if we can refer you to somebody that knows more about this, because obviously you're basically, we don't, we haven't talked about family. We've talked about you coming up from Fort Lauderdale. So do you have can you go back? What's there for you? What were the expectations? And those are the sorts of things that, that you may have legal recourse, and I don't want to say that you don't.
Huh. All right. Well, yeah, we're going to put up your number, I think, at the end of this next segment. We're going to take a break, and then we'll put up your number at the end of this next segment. And if people want to call in, there is the number to call into this show in our next segment, 615-737-PLUS. 615-737-7587. Take a break. Be back right after this.